Now to politics. The Edo Governorship Election Petitions Tribunal has also dismissed the petition of a court party alleging non-compliance and declaration of Governor Okpebholo as Governor of Edo State. The tribunal delivered 4 rulings. In the first ruling, the tribunal, led by Justice Wilfred Kpichi, stated that a court party failed to provide sufficient evidence to support their claims of non-compliance and resolved the motion against the petitioners. The second ruling addressed the court party's allegations that Okpebholo did not receive the required numbers of lawful votes, resolving the motion in favor of Okpebholo. In the third and fourth rulings, the tribunal dismissed the court party's request to declare their candidate the winner of the election. Now, joining us now to have a discussion on this is legal practitioner Elvis Asia. Elvis, you're welcome. Thank you very much for joining us.
Thank you for having me on the program.
So, Elvis, the tribunal dismissed the petition filed by the Action Alliance and a court party challenging the outcome. Do you think this was expected?
Quite frankly, this was fairly expected. Election petitions are very serious business. They are very technical issues. Even the way a manner of petition should be couched, all of those appears to have been flouted, particularly by their court party. So I'm not really surprised at the decision because, like I said, the Electoral Act details the way a manner your petition should be before the tribunal. And the burden on the petitioner, an election petition, is not a small one. It's really a very serious burden. And it will appear that those 2 petitions were not really, didn't meet up with that bar that has been set by the Electoral Act. And on that basis, they were justifiably, and quite frankly, questionably dismissed by the tribunal.
Judgment is based purely on legal grounds, unaffected by political pressure or public opinion surrounding the election results.
It's a difficult balancing. Whichever decision that comes out of a tribunal today will be celebrated by some people, and some others would accuse the tribunal of bias or some political influence. It's a very sad reality in our judiciary today. But before you can actually comfortably criticize the decision of the tribunal or any court for that matter, you must actually have looked at the facts as pleaded before the court. And so, unlike, contrary to the popular opinion out there, judges still, stick to the facts. In most cases, they still stick with the law. And electoral jurisprudence is quite dicey because, I have always maintained that the way the law is framed, it's almost an impossible task for a petitioner to succeed before in an election petition case. The hurdle that he must surmount to be able to succeed is so high that in most cases, tribunals are quite frankly, fairly criticized without due regards to the laws and, the evidence and the facts that are placed before them. So it's a difficult balancing that they have to carry out. The court must do justice without regards to sentiments, whether expressed in social media or by members of the public. What is important is that they have to look at the facts before them. They will have to look at the laws before them, and applying the law to the facts. They will come to a decision. You may not like it, but if it is properly, that discussion is properly exercised, it's always going to be very difficult for you to successfully accuse a court or a tribunal of bias if they stick with the law and the facts as placed before them.
Okay. So what if the tribunal rules in favor of other petitioners? What legal remedies or sanctions could be imposed on the respondents?
Well, if the tribunal rules in favor of the petitioners, then of course they also appeal, and then it depends on what you're asking. For example, in the case of the court party, they had various reliefs, including that they should be declared. And then they talk about irregularities and all of that. So it depends on what you are claiming for the relief that is being claimed. So if the relief is that you should be declared and you are so declared, but don't forget that the respondent who is the governor currently or the ruling party will still have the legal recourse of appeal. And until that appeal process is completely discharged, he will remain in office. So, what you get from the tribunal is a function of the reliefs that you are seeking, and those reliefs are circumscribed by the Electoral Act. You can either be asking that an election be, an election be set aside on the basis of non-compliance with the Electoral Act, or that you won the elections. And if you are asking for later, then you have to bring evidence. It's not enough to just say you won the election. You have to bring the evidence that shows that you have won the election. So the release will determine what the court will grant. But a respondent would always have the right to appeal. Until the appeal process is completely exhausted, one cannot really say as a final statement as to what relief will be eventually granted. So the respondent will have the right to appeal, and that appeal process will have to be concluded before you can finally determine what happens. But there are various relief that the court can make. The court can grant election petitions are sui generis, as they say. So it's specific with respect to the release that you are seeking.
Well, Elvis Asia, thank you very much for joining us this afternoon to give your 2 pence on the matter. Thank you.
Thank you for having me.